All right, a little early, but it looks like we have both parties present on the Osborne matter. So the court will call Bethany Osborne versus Mark Osborne, file number 23-19403DM. Mr. Osborne, can you hear me okay?
Yes, Your Honor.
And Ms. Osborne, if you could please unmute and let me know if you can hear me okay.
Thank you.
Thank you. In front of the court, what is the status of this matter?
Your Honor, the defendant has a monthly support obligation of $1,817 and a current balance on his account of $26,608.97. We have received partial payment this month in the amount of $665.12. However, last month and previous months were right around the $1,300 range. And so it's a little bit short.
All right, Mr. Osborne, anything that you'd like to say regarding this matter?
Your Honor, so before it was court ordered for child support, I was paying Bethany Osborne roughly $500 every paycheck, approximately $1,500 a month for months and months. And then when it was court ordered for the child support hearing, next thing you know, I get a letter from front of the court stating that I owe $25,000 in back child support, even though I was giving Bethany money. And immediately my paycheck started getting garnished. I'm only receiving barely $500 a paycheck. By the time I pay all my bills, I've only got a few $100s to live off of.
All right, Ms. Osborne, is it accurate that at some point you received money for support?
Yes, it was not consistent. However, he was giving me money. And actually, if you recall, when we came in front of you, me and him had a written up agreement where I was willing to accept a lesser amount. And he came into your courtroom and said he no longer agreed to it. So we then decided to let the court set the amount, in which they came up with the amount that we have now. And as far as his paychecks being garnished, he's not being completely honest there, because he has a paycheck from the VA on the 1st, of which he gets a certain amount per dependent that I get nothing from.
All right, so I see a support order that went into effect, looks like back in September of last year.
Yes.
That was for $1,800 a month, and that went, the effective date though ultimately for that went retroactive back to August of 23, it appears.
Yes.
So obviously, so in that period before that went into place, do you believe that you were receiving money towards child support, ma'am?
He was giving me money at that time, which I did speak to friend of the court about. They told me, and I told him, that anything I said, you need to start paying through friend of the court, because anything you give me, the courts consider not towards the child support amount. I said, you need to start paying through the court. And he did not. Also, during that time, I was still covering his cell phone bill and his car insurance. So part of that money was going towards that and not all towards the children.
Okay.
It was not consistent.
Can I say something, Your Honor?
Mr. Osborne, moving forward, what's the plan to get yourself full payments in and get yourself caught up here?
I'm trying to get my bill figured out. My bills figured out. I just finally started to almost get caught up being behind, and then a couple weeks ago, almost 2 weeks ago, I had a tree fall on my car, and I had to replace my vehicle, so I'm behind again. And then I also have a question. So it has come to my attention that 2 of my children are not even living with Miss Osborne. 2 of them are living at her mom's. The other 2 children are living at her sister's. So
Right, well, if you think there's an appropriate motion to review support, you'll have to file that. That's not on the docket for today, but that's certainly something you can do. And we can address that situation. How much credit do you think you actually have as for payments that were given to her directly?
I would probably say I gave her anywhere from $12,000 to $15,000 before it was ordered.
Do you have any way to account for that and have proof?
Unfortunately, I was giving her cash. I have a couple of receipts from money orders.
Okay. I mean, even with that, then you'd still be behind, over $10,000. All right, well, given the state of this matter, I do believe it's appropriate to refer the matter to Judge Hesselink on a contempt hearing, given the large balance in just a short period of time and not meeting the monthly obligations. Clearly, there's an arrears in this matter. I'm satisfied that you have the ability to pay, make the payments that were due and have not done so, have not exercised diligence in doing so. So I'm going to refer the matter. Will it go to Judge Hesselink or Judge Hunter? Because it's actually, he just did the trial on this matter. And I don't think a judgment's been in yet. So since there's no judgment, it's still an active case. All right. So we'll refer to Judge. Well, I don't have a Judge Hunter date, so.
I think it would just be appropriate that we can notice it and then it will go to the appropriate judge.
So we'll notice it up for a hearing. Mr. and Mrs. Osborne will let you guys know that date. It'll probably be sometime in April. Given the dockets, it may go to Judge Hesselink, but it may go to Judge Hunter where there's some changes in assignments. But given the status of your case, I'm not sure if it would be appropriate to keep it with Judge Hunter. So we'll send you a date to appear for that contempt hearing. I would indicate that if you make a payment of $8,000 prior to that date, then that particular contempt date would be canceled. And then, sir, if you have issues with the amount of support or what's going on, you need to file specific motions to address those, okay?
Yes, Your Honor.
All right, thank you both for appearing. You're all set and can sign off.
Thank you.